Chief Magistrate in the Rivers State Judiciary, Ejike George, has tendered his resignation from service, citing unease over the appointment of a sole administrator to oversee the affairs of the state. George, who disclosed this, said he has put in 16 years in the judiciary and the appointment of a sole administrator is tantamount to a quasi-military administration. George's resignation was contained in a letter dated April 11, 2025, and addressed to the Honorable Chief Judge of Rivers State through the Secretary of the Rivers State Judicial Service Commission, where George expressed dismay over the direction of the governance of the state, which he said is alien and antithetical to the values of the legal profession. He also said the present is intended to convey his decision to voluntarily retire his appointment as the Magistrate of the Judiciary of Rivers State, adding that the difficult and regrettable decision is informed largely by his discomfort with the recent appointment of a quasi-military administration to run the affairs of a modern state like Rivers State. I will start with you, Asim Adams. What do you make of this story?
Well, I believe the Chief Magistrate has the right, he has the premature to resign, voluntarily retire, or otherwise, because he was an employee of an employer. And there are terms of his employment which were, given to him. The only thing is that his own area now is a special area in the sense that he's a judicial officer. And judicial officers are just like civil servants, as the case may be. Under Section 292 of the 1999 Constitution, it spells out how judicial officers should be removed from office and how they can exit their positions. So I'm very sure that this Chief Magistrate must have gone through these sections and also looked at his letter of employment and terms of employment before he took that particular leap. He has to, I'm sure he must have looked before he leapt, as the case may be. But on the whole, I find it at times very difficult when I see judicial officers, civil, servants, acting based on political suasion and not moral grounds or general well-being grounds. Why am I saying this is that if, for instance, the reason he has given is best known to him, but it means that he said he has been affected by the situation on ground, which is a political situation. And you look at it and say that is the reason why I've said that all judicial officers are political animals. Whether you will like it or not, this Chief Magistrate must have shared some political affiliations with one or two political parties or personalities in government before he resigned or voluntarily retired. And that has been the biggest problem we have had in the judicature and elsewhere in Nigeria here, that civil servants who otherwise ought to be neutral in matters of its nature will jump into the arena and begin to, say because of a particular thing that has happened politically, then he goes to show that he wants to exit that place. Which means, if all things will be equal or to be equal, judgments, rulings, etc. made by some of these judges may be based on sympathy for a particular candidate or a particular situation. So I believe that we have so many other, I think Magistrate George in the judicature right now in Rivers State. Some of them have not come out openly to, say or maybe exit the space. But which means we have their kinds, on the bench that can be moved by political suasions and affiliations and sympathy. That is my own concern. Otherwise, the judges or the judicial officers ought to be very neutral and apolitical, as the case may be. But it didn't happen in this case. Now, I have also wondered, because I've heard that his resignation, I've heard also his retirement, voluntary retirement, etc., as the case may be. We have to put it to perspective. If I periscope the letter that he wrote to the chief judge or so, he titled it Voluntary Retirement from Service. And labor lawyers will understand that there's a difference between voluntary retirement, and resignation. These are different, genre or cadres, even though you might think that a thin rope separate them. Voluntary retirement, like he did, can only take place if he has served 10 years and above.
Okay.
That is why he stated in his letter
that
he has served 16 years
out of 22
of 22 years. He did that on purpose because he said, I am exiting. So 10 is okay, is 16, which means it's 6 years above the minimum required years for voluntary retirement. Resignation can be done even when you are employed today. The following day you can resign. They will not look at the years that you put into service. I can resign my service. I was employed today and I got a better job, somewhere. I look at my terms of employment. I say, okay, I give 1 more notice to my employer. I write my whatever to resign. If there are no conditions like that, I can just drop your biro and everything and go and take up that new job. That is resignation. So these, categories must be distinguished and categorized. Now, in case of voluntary retirement, because he's a lawyer, he's been there 22 years, he's a fairly relatively older lawyer, he knows the implication. He said voluntary retirement. Now, what does that signify? As he has voluntarily retired, he has smartly, made it that he will still enjoy his gratuity and benefits.
How?
Good, because he did voluntary retirement, which is a right, as opposed to outright resignation. So if you retire, normally if you have spent 35 years or 60 years, as the case may be, you retire by operation of law. You understand the point now? But when I have not reached 35, like in this case, he has not 35 years in service, and he has not reached 60 years or 65 years in the judicial in the bench, then he has to retire voluntarily, having spent 10 years to 16 years. So he is entitled to some benefits from that office. He can still go back to that particular office and get what retired people get from there. For instance, every year they say retirees of judicature are entitled to 1 cow or rice and beans. He's entitled to those things. But if he resigns, he cannot get those things because he has no attachment with the employer. That is the judiciary. He has no attachment. He goes home like that. So he smartly did this to put it in view forever. So that is on the ground of labor law and what has taken place here. It's a well thought out script, acted that he will not lose too much, in terms of facing the harsh realities, of retirement after. Because it also behoves that, I don't know, but I know that section 292, I think 292 sub 2 of the 1999 Constitution says that any judicial officer that is affected by the provisions of section 292 in terms of removal, in terms of retirement, in terms of etc., whatever the case may be, cannot practice as a lawyer. You understand? He can only act as a consultant. That is, as he is now, he cannot, robe and, go to the magistrate, the high court to go and defend clients, because he was once a judicial officer, as the case may be. I know of the judges, like the Supreme Court judges, Federal High Court judges, and the rest. But I'm still here to know whether Section 292, Sub 2, is inclusive of magistrates and customary court, judges. But I have found it. I don't think it's exclusive. It's inclusive, because some magistrates who have retired, or they retired or left the bench, I have not seen them practicing law. Okay. You understand? By virtue of Section 292 Sub 2.
All right.
It's a clear provision of the Constitution. So I'm sure you must have looked at the holistic approach, and intent of all this vis-a-vis the labor law. So it's a smart one indeed. Right. But on the other one, finally on this is that my concern is that we have many of them who are planted there. There are those who have sympathy for the governor. There are those who have sympathy for other political officers in Rivers State. So it then means that where lies, justice most times is being done on the platter of suasion and political sympathy and affiliations with this kind of situation.
All right.
That is what I feel about it.
All right. Very well. Honorable Kingsley, what do you make of this story?
I listened very keenly to my friend, the barrister. As a lawyer, he will be very careful to choose his words, because this actually relates to his own profession, so that he won't be suspended or given any query. But however, he was so careful to say the things he said, which I completely agree with him. But from my perspective, I am not a lawyer, I'm a politician. I see everything as politics. I've always said that. What he did very thoughtfully, and it is about interest, because politics generally is all about interest. If he hasn't any interest in the politics of Rivers State, I don't think he would have taken the decision he has taken, because of all the judges in Rivers State and all the civil servants. How come he was the only one who saw the reason to resign or retire, citing the state of emergency? One would have seen too many lawyers, especially those in the bench, to begin to retire as he has done, because there was a state of emergency. The state of emergency is not a permanent thing. We all know that. It is as a result of the state of things in the state that the presidency, using his power given to him by the Constitution, declared the state of emergency and was affirmed by the National Assembly. And so by the affirmation of that declaration, it therefore makes it legitimate, constitutional, lawful. And so if a lawyer who understands the law and understands the makings of law, seeing that this declaration was not done so motu by the president, but he followed the tenets of the Constitution by sending that declaration to the National Assembly, who thereafter affirmed by either voice vote or whatever the Constitution gave to them. Of course, even by the Constitution, the National Assembly have their rules that they operate with, which they did. He should have known that this was lawful, it was legitimate, it was constitutional. So citing that as a reason for me is no-go area. I see it as interest. He has proven his interest for the support of the suspended governor. And perhaps he has a reason for doing that, which may be between him and the governor, or the suspended governor, or between him and himself and his God. But in this case, I see a challenge. I listened to the lawyer. I see a challenge. Yes, it might be a thing he followed based on the labor laws. But I see this challenge because he has an employer. And having cited a reason in a crisis period for which he has retired, it is incumbent on his employer to either affirm by approving that his retirement or not. If that is not approved by his employer, it means that those benefits that he has smartly tried to gain, he may not get. Because if his employer sees that what he has done is political, and maybe he's trying to prove his support or his affiliation or his loyalty to the suspended governor, his employer might decide to punish him by not approving, because definitely that will go through the Judicial Service Commission. And the Judicial Service Commission has a leader who is loyal to the governor. And so when his letter of retirement, voluntary retirement, gets to the Judicial Service Commission, they might dump his letter. It is only when that letter is signed and approved that he begin to enjoy whatever benefits that he think he can enjoy. The highest thing he will do is go to labor court. And when you get there, your employer has reasons to defend himself, for which they will think that you retired maybe unlawfully or unjustly or whatever reason they could allude to it. They have their own reasons. But I think that he was not too smart enough. The emergency rule will not last forever. And he is a judicial officer who has served, as he has cited, for 16 years. And you know, the more number of years you serve, the more amount of pension and whatever benefits you will get when you have retired. And so leaving the office after 16 years, when he has more other years to serve, and he also knows that there will be a suspension of this declaration of emergency. And even if there was not, or there would be, there will still be a time when either this governor and another governor will also come, when he will still be in service, to still enjoy his years of service, and which ultimately will increase his benefits after retirement. So I think that he was not smart. My friend said he was smart enough. He was not too smart. He would have, you know, he's not the only person there. He would have kept silent. Because whether he talks or not talk, whether he responds or not respond, it has nothing to do with his service. He would have just kept quiet, allow the whole thing. The politicians should do their thing. He's a civil servant. Do your thing as a civil servant. So I think that he was not smart enough in his decision. But if he thinks he was, because it is dependent on him to decide what he wants, he has the right as a person. For me, as a politician, I want to solemnly say he did that based on interest, because politics is interest. Every human being today in Nigeria is a politician. Whether you're a lawyer, you're a judge, you are a woman in the kitchen, you see women doing protests and counter-protests. Some will wear black, some will wear white, and they are protesting. All of them are all geared towards interest. It's either you are gaining from those who ask you to wear black, or you are getting from those who ask you to wear white. Either side, all is interest. So I see everything playing out as interest.
All right.
What I wanted to add is that, yes, I agree. It's politics of interest and transactional politics, very prescriptive politics we play in Nigeria here. But I say that why I said he was smart, or the fact that I was thinking that he would have resigned, because all over the world, when you have a grudge against the system, you say, I'm resigning.
Simple.
Oli Babangida said, I'm stepping aside. You hear that the British Prime Minister resigned. You hear that the top civil servant say, I resigned. When you resign, you cut completely from the system. It means that the system you are working, you have nothing to gain from it again. You are tired of it. But when you retire, smartly like he did here, is that he still has some affiliations to the system. That means that if, for instance, the letter he wrote is accepted or acceptable to the JSC in Rivers State, he can still go there. He can still go to that ministry or go to that bench, whatever they call it there, and he will still hold people, and retirees of that particular, he is going to get the benefits of rice, beans, oil, or whatever they give to them, every month or every year end. And when they talk about retirees in Rivers State, he is part of the retirees. So that is where the smartness I'm talking about comes in. So, and that particular lastly, fuses and coalesces what my colleague and my good friend there said is about interest. So which means he acted smartly, using his office to now perpetuate his political interest and for him to be who he wants to be. For instance, you know that if Sim Fubara is now reinstated after the 6 months or maybe how many, whatever, he's going to call on him and say he's going to give him an award for being whatever, coming out to be the hero of wanting democracy in Rivers State, as the case may be. So he'll be getting from the system, surreptitiously. So that is why I'm saying that he smartly did this. But in Nigeria here, I don't know why we do that kind of a thing. A man from the Western world would have just resigned outright and say, look, I cannot bear this any longer, I am leaving. That is, you commit what they call political suicide, or you commit what they call bureaucratic suicide. You don't even go near them again. You understand the point? So, but this one is selective, in my own opinion.